As I call your name, if you could just unmute and let me know if you do have a name on the screen, whether that name is correct. If you don't, if you could tell me the name, your name, and the people in the room, that'd be great. And then who you're representing here today, whether you're a member of the applicant team, the applicant owner team, a neighboring property owner, or someone else involved with the project. So I'll start with a member of the zoning division, Wes Menzel. Welcome, Wes.
Morning.
And from there, I'll go to the office, the 18th floor label. If you could unmute and introduce yourselves. Still can't hear you there. Looks like you're muted. The folks in the conference room there.
Hey, can you hear us now?
Can, yes.
Okay, Kit Houston, Taft Law, on behalf of applicant.
Jeff Whelan with Whelan Builders, applicant.
Okay. Mr. Houston, could you spell your last name for me?
Sure, just like the city of Houston's, Houston.
All right, great, thanks. And I see we have Carrie McAndrews here.
Yes, hi. I am a resident of Walworth, 2903 Walworth.
Okay, great, welcome.
Thanks.
Peter, is it Salamini?
Yes, sir. Also an attorney for applicant.
Okay, great. And we have, looks like Patricia Belia. Sorry, I forgot to pronounce your last name.
That's okay. It's Patricia Bellier and my husband.
Kerry Bellier. We are 2891 Walworth, next to the subject property.
Okay, great. Patricia and say Walter.
Carrie, C-A-R-Y.
Great. Great, welcome.
Thank you.
Then I see we have Rob. I believe that's Rob Linneman.
Rob Linneman from, thank you, Mr. Sturkey. Yes, it's Rob Linneman from Stanton and Hughes. I'm attorney for Carrie and Patricia Ballier.
Okay, great, welcome.
Thank you.
We have McAndrews, the other McAndrews in the office.
Brendan McAndrews, 2903 Walworth.
Welcome. And then someone under Rob Lotz.
Yeah, Rob Lotz, attorney for applicant.
All right, on the applicant owner side, are we expecting anyone else to join us here today, or are we ready to proceed?
No, sir, we're ready to proceed.
Okay, great. I need to, before we actually start, I'll need to read through our hearing script, and then we'll get into it. So this is the May 8th, 2024 session of the Zoning Hearing Examiner docket. Again, my name is David Sturkey. I'll be presiding over the hearing today. The case before us is case number ZH20240042. That is 2885 Walworth Avenue. The purpose of this hearing is to allow applicants and any potential opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the Zoning Hearing Examiner. All testimony and evidence that an applicant or any potential opposing parties wish to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. For our purposes here today, for the attorneys, for the applicant, you can really orient that presentation however you'd like. You can do sort of a more traditional legal presentation where you offer opening statements and then sort of direct exam or ask your client questions. You can make opening statements and then turn it over to your client to make any statements they would like. It's really however you would like to orient the presentation. I will then move to members of the public and give them an opportunity to speak after the applicant has presented its case. If the applicant is represented by an attorney, which they are in this case, the applicant's attorney may cross-examine any person who testifies at this hearing outside of any government officials. If a party of record is represented by an attorney, the attorney for the party of record may present witnesses after the applicant has presented its case. and may cross-examine any person who has testified at the hearing. So Mr. Linneman, you'll have that opportunity at that time to present your clients as witnesses and allow them to testify. And then of course to cross-examine anyone else that has testified at this hearing. After the applicant has been given an opportunity, or I'm sorry, in the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to respond or rebut to that testimony or argument. So again, back to the applicant's attorneys, you all will have a chance to respond to any of the testimony from the neighbors and from the Belliers. After the applicant has been given an opportunity to rebut any testimony offered in opposition, any attorney for a party of record. So again, Mr. Linneman, you'll have an opportunity to make any closing statements. And then finally, the applicant will have an opportunity to make any closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those on the fly. But to the extent there's some defect that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, and after having said all of that, I am going to go a little bit out of order today, and I'm going to allow the zoning plans examiner for this before he provides any testimony in terms of his analysis. I am going to start with him today to just do some table setting so that we're all sort of in the same place here and understand what exactly the relief is that's requested and how, if at all, that differs from the prior case. All right, last thing I'm going to do here is just swear in all of our witnesses. And so if you intend on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing today, and you are not an attorney, then I need to swear you in before your testimony. So I'm going to try to collectively do that right now, again, for all non-attorneys who intend on providing any testimony. If you could take yourself off of mute, I need everyone to raise their right hand and to answer out loud. You solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth.
I do.
I do.
Okay, great. Thanks, everyone. All right. So, Mr. Houston, will you be taking the lead here for us today?
Yes, sir.
Okay, the floor is yours.
Okay, great. Did you not, you wanted the zoning, the city to go take the lead first? Okay.
I absolutely did. Thank you. Wes, can you tell us a little bit more about why we're here today and what the relief is that's requested?
Sure. Good morning. So as you all recall, the last year there was a zoning variance request for this property for height for the entire top level massing from front facade to the rear facade. There was a height variance request, and that zoning case was denied. And subsequently, the applicant revised their plan to conform to the height limit in the rear for the facade, the parapet wall, the safety railing, and the decking, shifting things towards the front. However, the front massing did not change and still requires height relief for the front facade and the front part of the home. I think there's some drawings in the staff report that show a little bit more about that. If we can get to those later, that would be part of the discussion. So.
Sure. So the first time that the applicant came through, he was requesting relief in the front and in the rear of the building, and today they're bringing in a plan where the rear of the building and the deck is actually conforming to the 42-foot height limit, and they're just asking for the front.
That's correct.
Okay. All right. Great. With that, Mr. Houston, I'll turn it over to you.
Yes, thank you. So I'll do just a quick opening statement, maybe to add on to that history, and then we'll place Mr. Wieland up on the stand, if you will, to ask a few questions. So sure. I think it's important to note, as was indicated by the city, that the prior appeal dealt with two issues: nonconformance in the rear of the structure and the front of the structure. The contentious point of the objections to the prior appeal were based on the non-conformance of the back of the structure. That's no longer an issue. So now we're just dealing with approximately 1 foot 9 inches of roof height in the front of the structure. And for reasons that will be explained by my client here, there is absolutely nothing that can be done to bring that roof down that's economically viable. If you look, and I think it's important to also note that the variance is being requested for the structure as constructed today. Exhibit F of the applicant's brief, or the as-built plans for the structure, is important to note that the railing on the back of the structure is not currently installed, but will be installed per those plans. If this body does decide to grant the variance as constructed, that would be the only change as the structure stands today that's different from that Exhibit F as-built plans. But important to note again, the rear of the structure will be in compliance.
Okay.
We've also, applicant has been in discussions with some of the neighbors to try to work out an agreement to forego any objections to this appeal. One of the requests was removal of the current parapet wall. Even though no agreement was reached, the applicant is still willing to remove that wall as part of the changes to bring the structure further into conformance. So with that said, we'd like to ask Mr. Whelan a few questions. So Jeff, can you state your name for the record, please?
Jeff Whelan.
And what is your position within the applicant Whelan Builders?
I'm president of Whelan Builders.
Okay. So you're generally familiar with the day-to-day operations of the company?
Yes.
Okay. Are you familiar with the brief that was filed on behalf of the applicant in this matter on April 1, 2024?
Yes.
And are the documents attached to that brief what they are indicated to be within the brief?
Yes.
Okay. We understand, as there's been some discussion today, that the initial application for the variance was denied before this body. Is that correct?
Yes.
Okay. And can you let us know, since the application was denied, what all changes have been made to the structure?
In our previous attempt, we had the railing that was going above the parallelogram, that how you measure the height on the hillside district. And as well as the back, I think it's like 6 something feet portion of the parapet wall is also there. And we've agreed to take the parapet wall down, and we're moving the railing forward to where it's 13 feet 10 off the back of the house on up there to where it's in compliance within the parallelogram. And so that was the biggest issue we had before, was the back of the house being 1 foot 9 too tall, and that was into that railing area.
And in your opinion, has that affected the value of the home?
Absolutely. It's yes, it's very negatively affect the value of the home.
Okay. So the as-built plans, which are attached to your brief as Exhibit F, are they a true and accurate depiction of the structure as it stands today, other than the back railing has not been constructed?
Other than the railing, we didn't put the railing up, and the parapet wall is still intact right now, and we plan on removing a good portion of the parapet wall.
Right, but according to the city's zoning decision, which is attached as Exhibit D, the back of the house is in compliance. Is that your understanding?
Correct.
Okay, so the only portion of the structure that's currently not in compliance with the City of Cincinnati code is the front of the structure?
Yes, according to the city's letter.
Is there anything that can be done to the front of the structure to bring it into compliance?
There's not. The way that the parallelogram is measured and on the front of the structure, and where our wall is, where you walk out the door to the back rooftop porch, it doesn't allow us to, even if we took the top portion of the roof off, that wall is still the pendulum point where you cannot get it down underneath the parallelogram.
So the only way to bring the structure into compliance would be to remove the top floor. I believe it's the 4th floor. Is that correct?
The 5th floor, and yes, yes, but there's a lot of moving parts, and we've looked at all of them. We've had our architect there. We've had a number of different ways to try and remove the wall to where it's not the pendulum point, and there's stairs that are there that affect that we can't move the wall and still be underneath the parallelogram. We've exhausted as much as that I could possibly do.
And how long have you been in the construction business?
I've been graduated college in 1997. So that's 27 years. And then, I was born and raised in this business. So I started working when I was in 6th grade.
So you have a lot of experience, it's fair to say?
I do.
Okay. Can you tell us, I believe you made some accommodations for the neighbors that weren't technically required by law, something to do with landscaping. Can you just walk us through those as well?
When we were under construction, we had a number of, our foundation is 18 feet tall, 18 plus feet tall. And in those, on that street, when you dig into the basement, into the soil, it's very unstable. And there was the neighbors to the east of us, Belliers, had a retaining wall that was there and some landscaping, in the same way with Mr. Walderman on the west side of us. And when we were digging the basement, we had a number of cave-ins, very dangerous cave-ins. Even the utilities crushed into the hole and made a very dangerous situation. When that happened, the grades adjusted, the landscaping, died, and the retaining walls had to be replaced. So when we constructed our foundation wall, we constructed the sides of it to adhere to both grades on both neighbors. So it's not like our house is just on the sides where it's affecting the grade. Extremely out of compliance with that. We came back in and built a retaining wall between the two houses as we met with the Belliers, and we talked to them, and we agreed that was the best way to move forward. They have their air conditioner units on that side. We had some, as you get towards the back of the house and bringing the grade down, we worked together to get that resolved, to get the landscaping resolved. We replaced their landscaping back to its original form. And then we did the same thing with Mr. Walderman on the west side to get their landscaping back into its original form. It was very, as you guys know, everybody lived there. Very tough situation.
Understood. And so, in your opinion, the height issue here is the main thing at play in your mind, the views and how your structure could affect other property owners' views?
I think that
has that been expressed to you by anybody?
Oh, absolutely. Yeah. I mean, from the neighbors, they say it's affecting their views, and I mean, it's a difference of opinion. I mean, you're in the hillside district, so that's what everybody talks about is the views. The river dog legs around in the city of Cincinnati is what the view of everybody talks about, is what they want. You can still see that from all angles, from different places. I think people thinking in terms of this view allowance, you're thinking about either 180-degree views or 90-degree views when you have plenty of places to see different things. It's a matter of opinion. I sit there and look at it and think there's no problem with it, and somebody else could look at it and say there's all the problems with it.
Okay. So, but the primary complaints were on the back portion of the property previously, because that's where the views are. Is that correct?
That's the only complaints that we have is on the back part.
And do you feel that the structure as it currently stands kind of fits the character of the neighborhood? Does it look out of place to you at all?
It does not. When you stand on the street and look at the front of the house as the house is stepped down, Walworth is in this portion is pretty flat until you get to where we are building at, and then it goes up the hill. And as you look down the hill, our house fits into, it conforms with the rest of the homes as you look at the front of it.
Okay. And one final little line of questioning here. Can you tell us how, or is it fair to say that the construction of this home out of conformance with the code was an honest mistake?
Absolutely.
And can you tell us how that mistake occurred?
From what we've found in this process is that the back alleyway, so there's Walworth Avenue, and then there's the back alleyway behind the houses, and there's it's a concrete driveway, and that driveway, as it approaches this project and towards the end, is 1'9" higher than what it says on the record plat. And I don't think we really knew that the last time. I mean, we knew it, but we didn't really have it documented well enough to understand when we are digging the basement, we're not all standing up on Walworth looking at it and digging the basement. We're all running our trucks. We're setting our instrument up on the concrete driveway behind the house. That's how we shoot our laser transit to get our grades. That's where we based everything off of. And that's 1'9" out. Our house is 1'9" too tall. And that's the best I can explain it.
So to summarize that, it's fair to say that you base your plans on the street elevation plans as they were drafted, and those plans changed, causing your structure to be out of conformity the exact amount that the street was out of conformity. Is that fair?
That's correct.
That's all we have.
Okay, great. I think for continuity's sake, it would make sense to allow Mr. Linneman a chance to ask Mr. Whelan some questions on cross at this time. So, Mr. Linneman, do you have any questions for Mr. Whelan?
I do, yes, thank you. So, Mr. Whelan, I'll start with the point you just made. First of all, good morning. Nice to see you again. We've met before. Good morning. You submitted exhibit, I believe it's what you're referring to as Exhibit A to the materials that you submitted in support of your application. Do you agree with me on that? Do you have those in front of you?
So Rob, can you repeat that question? It was unclear to me at least.
Yes. Mr. Whelan, you submitted Exhibit E, which is you referred to some sort of record plat. Do you agree with me? Mr. Sturkey, am I empowered to share my screen? I can put it up if that's possible.
Yes.
Yeah.
Exhibit E is the record plat.
Yes, you can share as well if you'd like.
Mr. Whelan, you agree with me that this plat is not signed, nor does it bear any stamp that shows that it was recorded. Do you agree with that? And if not, if you can point me to the signature of the stamp or the recordation indications, please do.
Correct.
Okay, so we don't know. This is not an official document. This appears to be some draft from some point, but we don't know where it came from. Is that right?
Are you saying that this is not the recorded document?
The
That the recorded document doesn't look like this? Is that what you're saying?
The question was, this does not bear a stamp indicating that it is the recorded document. Do you agree with me?
It doesn't have the engineer's stamp on it.
Okay. Do you agree?
But I'm not saying that this is not the recorded document, because everything on here could be the record plat. This is a copy of what is supposed to be the record plat.
It could be, no question. But we don't know if it is. Do you agree with that?
I don't agree with that, because I received this from the engineer of record for Walworth Junction.
Okay. But it isn't a recorded version. Good enough. Let's see. I'm going to stop sharing now. But with that said, can you indicate to me the point that you're referring to, the elevation at the rear of your property that you're referring to? I think, is it true that your lot 38? Is that the subject property? It's over to the left. I'm going to share screen again so we've got it in front of us. Am I correct that it's lot 38, right?
Yes, you're correct.
Okay. Where is the elevation point on that road that you're referring to? Do you agree with me that there's not the road doesn't exist as of this drawing? The road is this dash drawing right here, the alley that you referred to?
That's where the road's located at. Is that what you're asking me?
Yeah. So where's the elevation point that you were referring to that told you what the height was at the road?
Give me a minute to find this. If you look at Exhibit F.
Okay, you want me to switch to a different exhibit?
I believe it would be page 7, and we can revert back to your record plat drawing if you want after this, but where you can see down there where it says 524, that's what it's supposed to be, and that's what's on that record plat drawing to say that that's what the driveway was supposed to be. And then you
Well,
can
but
see
that's a grading, that's a contour line, right? That's showing a surface. That's not showing a point, right? That's a contour of the hillside. Am I right?
it's the grade line that they use to shoot the grade there.
Okay. And do you agree with me? So that's 524 feet in elevation. Is that what you're referring to? This right here?
Correct. That's what it's supposed to be on the record plat.
Okay. And we can see here in the southeast corner, it's 523.4. Do you agree with me that that's lower in elevation than 524?
Yes.
Okay. And I can see here that at your other corner, it's 526 and 3/10. Do you agree with me that that's higher?
Yes.
So the grade is increasing as you move east to west. Is that right?
Yes.
And your point is that this measurement right here, 525.78, is higher than the 524?
Yes.
Okay, but this elevation, the 525.78, that's your finished driveway, right?
Which is at the street. The alleyway.
I'm sorry, say it again.
That's the driveway at the meeting point of the alleyway in the back.
Okay, but that's a finished point. That didn't exist when the initial drawing was taken, right?
Can you repeat that? Sorry.
That your driveway didn't exist at the time, right? That where are you saying that point exists? Or is it this corner?
Rob, we're unclear what time you're talking about.
Let's say right now, just for reference. First of all, what we're looking at purports to be an as-built drawing, correct?
You're asking if exhibit
F.
Yeah, can you restate the question with a specific exhibit reference?
Is exhibit F an as-built drawing? Do you need me to repeat a question?
Well, I mean,
I'm
the
looking.
document states elevation as built, so that's what it says.
Okay. Well, so same question then over here. I see this is 523.97, right over here on the east side. And on the west end, your point is that it's 527. So there's a slope from east to west and from south to north. And somewhere in there, it must have hit 524 feet. Is that right?
Yes.
Okay. Okay, no, it is your contention that what you submitted at the rear of the house is in compliance. Is that correct?
According to the letter coming from the city, yes.
Okay. So first of all, I'm looking at exhibit again. I'm looking at exhibit F. I'll share my screen again. I'm going to put up. I'm looking at what you submitted as exhibit F. Do you agree with? Does this look like your exhibit F? Do you have it in front of you?
Yes.
Okay, and over here in the corner, it says as built with front elevation. But you said earlier that you plan to remove the parapet wall which exists. Is that correct?
That's our plan to do so, yes.
Okay, so this drawing is not as built in the rear, right? This section that I've highlighted is not actually as built, correct?
We stated that in the beginning, yes.
To be clear, it's as built with the exception that the railing has not been reinstalled, but the document depicts how the railing will be installed. And the parapet wall, as we stated, is only being removed as an accommodation to the neighbors.
I'm sorry, Kit, is that, just so we're clear, is that Kit talking or is that Mr. Whelan talking?
That is me correcting the record.
Who's me?
Kit Houston.
Okay, thanks, Kit. Sorry.
Yep.
Well, but on that point, I think I'm not sure I understand. You said it's as built, but true or false? The parapet still exists in the area that I've just highlighted. Is that true or false?
We have not removed the parapet wall yet on the actual house itself. We haven't put the rail up. We haven't made any adjustments to it. We were waiting to get through this hearing.
Okay, understood. So what you're saying is you under your proposal, you are going to build to what is pictured here. Is that a condition that you're offering in this proposal?
No, we are going to remove the entire parapet wall and take the railing down, where this is just showing us removing the parapet wall for 6 feet. We're going to remove the entire parapet wall.
Okay. And I see here also highlighted on this, here, this is the area I'm going to look at right here. It's the rear of the property. And I'm going to zoom it just a little bit so that we can see that more closely. Okay, now this depicts a gutter on the rear of the property. Are you planning to change the drainage so that the gutter's now on the rear?
Hold on.
The gutter is not on the rear of the property. The gutter is on the side of the property.
Okay, so what's the plan with why is the gutter depicted on the rear of the property now?
I cannot answer that.
Okay. In order to get to this line, do you agree with me that whoever your architect was, in order to get to this line that shows the building envelope, they used that point where right now a gutter is depicted, and right now it's below the parapet. This is right now the parapet wall exists there. So this point cannot presently be seen the way it is seen. Is that true?
I'm sorry, could you repeat the question?
Yeah, actually, let me ask a better question. This also depicts pavers in this area. Is that what those are? Are those pavers right
Yes.
here? Okay. And it shows that those are scaled back from the rear of the building. Do you agree with me there that in this area here, the pavers are
Yes.
scaled back? Okay. So you intend to scale the pavers back in order to bring the building into compliance. Is that correct?
It wasn't our intention, but if this is something that is going to make everybody happy, then we would be okay. I was leaving them there because it's unsightly to look at the rubber roofing, and it protects the rubber roofing. I didn't think that it was going to be that big of a deal, but we can remove those pavers in that 4-foot section there.
Well, my main point here is
2 feet.
Okay, well, thank you for that. But my main point is figuring out how somebody came to this point, which is being used to determine compliance. This line, the line for the building envelope, is centered on a point which right now, which is yet to be constructed. So in order for this all to be in compliance, you agree with me that the parapet wall has to be removed to this point, and this area, this precise point right there is what determines your building envelope. So you need
Kit Houston here. I would only interject to say that this portion of the building is not the subject of the appeal. Per the city's decision, the back of the building is in compliance. We're really here to talk about the front roof. Happy to continue along here, but just wanted to point that out. Rob, if you could restate your question, Jeff will do his best to answer it.
That's noted, Mr. Houston. But Rob, go ahead and continue.
Sure. Well, Mr. Whelan, do you agree with me in order to, if it's correct that this is that your building envelope is in compliance, but by the way, just to respond to that objection, the scope of this variance is determined by the building envelope determination, which rests entirely on this, or which rests at least in part upon this place right here. If that's not correct, or if it doesn't exist yet and it is yet to be built, then the determination about the front massing is yet undetermined. So it is relevant to both the front and the back because it is a point that is necessary to determine the height of the building envelope. So I understand your point, Mr. Houston, but we do, whether it's relevant to both the front and the back here. So just to wrap this up, Mr. Whelan, this point right here requires that in order to come to that calculation of the building envelope, you agree with me that we have to remove the parapet wall, we have to get below the level where the pavers presently are, and we can disregard this gutter that doesn't exist, but we have to get to this point, which is marked top of building height limits. Do you agree with me that that's where that altitude is?
So I understand your question. You're saying that we should remove the pavers in order to get to the 565.5. From my understanding of the way that the height is measured, because if you're going directly from the bottom of the grade up to the top of the building, we are below the dimensions which is required. But the heights are determined by the averages from left to right across the back of the house, from left to right across the side of the house. And the way that that's measured is perpendicular to the parallelogram. And so I think to say that, to sum this up for you, if you want us to remove those pavers and it's going to help the sight lines on this project, we will remove those pavers on the back. Maybe that looks like 1.5 to 2 feet of the project. But yes.
That wasn't exactly. I was not asking you to offer any kind of condition. If you're saying that you're willing to do that in order to do it, it's fine. But all I was trying to do was ascertain how you came up with your calculation of the building envelope. But so
we came up with it by having the engineers go down and physically shoot the grades from the bottom, from the top, from the peaks of the roof, everywhere that they possibly could to get their actual elevations to draw this drawing.
Okay, understood. Mr. Whelan, is there anything? I was about to unshare the screen unless there's anything that you need to further elaborate on what you just said. I'll unshare the screen. Okay.
No, sir. I'm good.
Okay.
Mr. Linneman, any more questions for Mr. Whelan at this time?
Yes, one or two more. I'm almost finished. Thank you.
Mr. Houston, I'll give you a chance to redirect as well if you would like.
Thank you.
Mr. Whelan, when the parapet is removed, then again, what will remain? What since the drawing exhibit F showed the parapet still in existence, could you describe? It sounds to me like you've changed what that proposal is. You're going to remove the parapet from the entirety of the rear of the wall or of the rear of that floor. Can you tell me what will be left? How will it be just flat, and at what elevation will it be?
We haven't changed. Per your just recent drawing and request and talking about those pavers, we would have to remove that parapet wall completely. And what the Belliers and I discussed the other day in a meeting at the house was if I could leave a plate on top of, instead of the parapet wall being, say, 14 to 16 inches tall, it may be 3 inches tall. I'm sorry, I don't know the exact number, but it may be 3 inches tall, and I would run a plate across the top of there. And the only reason I was wanting to do that is because it's a rubber roof. And right now, the way the parapet wall is held onto the roof, it's framed down inside the walls, and we have rubber roofing that's flashed up around there. And there's a number of different things that go on with that. When I have to cut that off, now I have to patch the rubber roof, and it just opens itself up for an opportunity to leak. And I was asking them, would it be okay with you if I left that top plate on there, which would make the parapet wall, and I don't even know why we're calling it a parapet wall. It's basically the bottom plate of a railing that would extend maybe 2 to 3 inches up above the rubber roof that's there right now. And it would give a consistent level place for the railing to sit on. That was a request. You know, if that's not acceptable and I have to cut everything off of there and we put the railing down directly on the roof and we put the pavers around those newel posts that hold the railing up, then that's what we'll do. But that was the discussion we had.
Okay, why do you need the plate around? Would that plate then go all the way to the edge of the roof and around the perimeter of the roof? If I understood you correctly, it seems to me you'd only need the plate in the 13.6 or the 13-foot, 10-inch area from the back of the house.
It would have, only because on the entire back of the house it's pitched, and the entire back of the house is all parapet wall. There's no spot openings for the water to run out because the water runs from left to right, and it would have provided a cap on top of that area as well. And it doesn't sound like, you know, when you look at that drawing, if I were to do that, then it's going to leave the parapet wall, so to speak, on that section. I'm just trying to make everybody happy with it, man. That's all I'm trying to do. So if I have to remove it, I'll remove it. But I just feel like this is something that is not necessarily blocking the view. It's just going to help us prevent a leak from happening in the future.
Okay. What, sir, this is the second piece of proceedings that are currently pending on this property. If you have an administrative appeal of the decision that was earlier mentioned, what is your intention with respect to that appeal concerning this property?
I really don't know how this all works, but if we get this variance approved to move forward with what we talked about today, I don't see the purpose of keeping that appeal alive. In fact, I don't even know if it's still alive. I thought there was a time frame for it. The only reason we appealed it was because we felt like there was it's a court thing. There's like a time frame that you have to do it within in order to keep it moving. And the only reason we were keeping it moving is because this is how my fate flies with this whole project. So if we get a positive outcome from today, I can't imagine why we would keep the appeal open. We would want to all move forward.
Okay. Thank you, sir. Mr. Sturkey, that's all I have. Mr. Whelan, thank you very much for your time today.
Thank you, Rob.
Thanks, Mr. Lemon. Mr. Houston, did you want to follow up with Mr. Whelan on any questions on redirect?
Yes, sir. Just ever so briefly. Mr. Whelan, you're not an attorney, right?
Correct.
Okay. The discussions we've had about how the mistake was made in the construction of this house, and in regard to the street elevations, again, regardless of what those plans state, can you reaffirm to this body that it was an honest mistake? You did not construct this home out of compliance on purpose?
100%. We did not. I did
And,
not construct this out on purpose.
okay, and as far as the back portion of the house and the discussion about this I believe it was a 2 to 3 inch plate, that portion of the parapet wall is well below the building height requirement. Is that correct?
Correct.
Correct. And despite the fact the city has not objected to the back of the house in its decision that's currently being the subject of this appeal, if you will, you would be willing to make further changes to the back of that house as a condition to the grant of this variance. Is that correct?
Yes.
Okay. No further questions.
Thank you. All right, Mr. Houston, did you have any other witnesses that you wanted to call, or any other statements you want to make at this time?
No, sir. If possible, we'd like to reserve a few minutes for closing.
Absolutely. Okay, I think now we'll move on to the public. Allow Harry McAndrews and Brendan McAndrews to provide any testimony, and then Mr. Linneman will move on to your clients. Miss Carrie McAndrews, anything?
I just wanted to say that, everyone down here wants to enjoy their view, like peacefully without any issues. The Wheelan home is beautiful. It does look different from the front. No other home has more than 2 steps, and I think they have 8. It is a beautiful home, but it does stand out when you're looking at the street. So, everybody wants this to come to like a resolution, but TBD on what that is. So.
Okay. Thanks, Ms. McAndrews. Appreciate you being here and at the last hearing. We'll move on to, is it Brendan? Did I get that right?
Yes, that's correct.
What would you like to tell us?
Yeah, I mean, like she said, I mean, the home's beautiful. We look forward to having neighbors in there at some point. A vacant home's not good for anybody. But at the end of the day, we want to make sure that the Belliers, who are our neighbors, have a good view, and the way in which they built their house should be within compliance. The house is obviously taller. It's the same height as on 39, and 39 slopes down into 38 when we're talking about lots. Nobody wants to walk out. I mean, we only have 10 feet between homes. So when you walk out on your porch, if the house is too high next to you, it kind of hugs you, and it becomes part of your ambiance and feeling every single day on it. And it kind of quashes the fun you can have, or makes you feel a little more claustrophobic when it really didn't need to happen. At the end of the day, we just want to resolve, and we want everybody to have a fair shake at it. I know Jeff's, I can't imagine this project was profitable and you just keep taking it, and I feel horrible for you on it. And so, we want it to come to an end too. So hopefully there can be a good resolution for everybody to get it there. But I definitely want to make sure that the Belliers don't lose their view to a big side blue wall that we can see clearly from our home.
Okay, great. Thank you. Mr. Linneman, I'm gonna turn it over to you with sort of the same guidance that I gave Mr. Houston. You can orient your presentation however you would like, and the floor is yours.
Okay. I think what I'd like to do is make a request to see if the applicant will spare me some direct examination of my clients on some points that I think that don't seem to be at issue, but I think I would otherwise feel obligated to put on the record, and that'll take up some of our time. These are all things that we covered at length in the first variance proceeding of about this time last year. So if I will ask that at that time, we put on documentary evidence and testimony by which we established that, or by which we suggested that the property, that is the Ballier property and the Wheelan property and all the properties in the development, were marketed by the developer for their views, for the views from the lots, various places in the lots. Number 2, the purchasers bought their properties in order to obtain those views. Number 3, the purchasers relied upon construction in conformance with the existing zoning code. Next, I'll change the character of this. We put on evidence showing that the Balliers had exercised diligence in asserting their rights here. They had identified the problem with the height very early in construction. They had contacted the zoning department with the city, and they had also ultimately contacted Wheelan Homes. And then finally, that the Balliers believed that the grant of a variance would negatively affect the property value, negatively affect their use and enjoyment of property. I could go through in direct examination at some length to establish all these things. Unless the applicant would stipulate to them, then I'd be happy to just accept that stipulation and move on.
Rob, as much as we would love to, we did not represent Wheeland in the prior matter, so I just don't feel comfortable as counsel stipulating to anything. Apologies if it's going to extend the hearing, but it shouldn't take too long through direct to establish that.
Okay. Let's see. Tricia, then why don't I start with you?
Sure.
Why don't you, do you want to, I'm just going to open the floor to you. I'll let you, because I know you have some things to say. So why don't I just allow, Mr. Sturkey, if that's okay, that is, by the way, I'd like to just offer Tricia Ballier the opportunity to provide her view. I'll probably follow up on some fine points addressing those 5 things that I just discussed. But Tricia, with that, I will turn it over to you.
Sure. And certainly, as Rob, as you said, these are all things that we discussed during the very first time that we had the variance hearing, and most of the people that are here today were a part of that as well. But to go back to that, we chose to move to this area after being 25 years up in the Westchester area, and we chose to move to this particular area based on the marketing materials and what we saw from drone footage as to what our view would be. And actually, the lots themselves were priced differently based on the view that you would be afforded by building your home at that particular lot. We were one of the first 4 lots that were purchased. And as part of that choice of which lot, it was truly based on what we would be able to have as a view in building a home in this location. With that, we also understood that there were limitations around the design and what we could and could not do as part of the development of our own choice of our property. And even our designer, our builder, had to make some accommodations and make some changes from the original design to what was actually then approved and what was going to be built, based on making sure that we conformed to what was in place and what was stated as to what was allowable on this street. So we went through that process ourselves, and we made sure that our property met the specifications that needed to be made for this location, understanding that that was the expectation. And all of our other neighbors have been through that same process and had to build their homes under the same specifications as well. On April 20th, 2022, Mr. Wheelan's brother, Mike, was the individual that actually did the excavating for their property. And when he did that, there was damage done, as Mr. Wheelan has said, to both our property and the property on the other side. And that property on the other side, Ed Walterman's property, is a property that Mr. Wheelan built. And so he very much knew what the design was of the street, what the elevation was at this end of the street, what was there from a back street, was all in place when he built the first home that he built right next to it. That excavation then resulted in all of our utilities going down into the excavation, as Mr. Wheelan stated, and caused a very dangerous situation with a gas leak, electric leak, and having to tie into neighbors' power to be able to then have power on our end of the street, and did do major damage to our landscaping and to our neighbors' landscaping as well. That was just finally taken care of 1 year later. So it was 1 year of construction of damage to our property and other properties adjacent based on the mistakes that were made when the original excavation happened for building that property. When the foundation was poured, it was very apparent to ourselves and all of our neighbors that commented to us and stopped and looked at the property, because we have a very close group of neighbors on this street is one of the wonderful parts of it, that the neighbors talk to each other. They participate in a lot of activities together. And this home building, from the point of the excavation through today, continues to be a topic of conversation for the whole street and what is going on with it and what happened. When that foundation was poured, we very much, like I said, noticed ourselves, it was considerably higher than ours and higher than what would be the next property up, Ed Walterman's property. And if you look at the foundations going up the street, as it's already been mentioned, it's graduated. And so each one of them have a slight graduation higher than the next one. And this one was noticeably much different. As also has been established, Mr. Whelan is a very accomplished builder that has built for many, many years. I am not, my husband is not, our neighbors are not, but we all noticed this and we all questioned it. We questioned it to the level of bringing it to the city's attention in June of 2022 and didn't hear anything back, so brought it back to their attention in August. At the same time, their general manager was coming out to the property, and I was having routine discussions with that individual, Terry, because I was asking what's happening with the damage that's been done to our property, and also, like, why is this foundation so much higher? And at the time, as I've spoken to before in the first variance hearing, I was very much told to, basically, don't worry about it. We're going to make this a beautiful home. We'll cover this with stone. It'll be beautiful. And the questions were never truly addressed. So that's why we've continued to kind of want to understand how this is going to happen. As was mentioned by our neighbor, Carrie, the original plans that we saw that were at the home had a 3-step entryway. There are 8 stairs into the entryway. And again, as an accomplished builder, how that change in needing to make a change to what you're building from 3 stairs to 5 stairs to enter the property wouldn't be something that could have been addressed as to what's happening here and why we're needing to make these things. Again, I'm not a builder, I don't know, but that certainly would be a red flag to myself. And again, plays into why we find ourselves where we are today, which is extremely unfortunate for everyone that's involved. And, I can only say is, and I think what I appreciate our attorney trying to bring to attention is, I understand this variance is talking about the front of the house, but the front of the house is based on where the point is that you start in the back of the house. And the back of the house is what we have said all along, makes a significant difference to us. We have tried to be open to discussions with Mr. Whelan and his attorneys, and it has not been a very collaborative activity. We are trying to understand what other options there are. And even in this last moment, we were never contacted with this latest variance request to have any kind of discussion around how to possibly help them with this and go through any other alternatives, which again, just plays into, this has not been a collaborative activity for the last 2 years. And we find ourselves in a place that is very unfortunate and uncomfortable for us as well. I think that's all I have to say at this point. Anything that you'd like to ask me, Rob?
If I could, yes, please. Thank
Sure.
you, Tricia. Well, first, can you describe the effect of we've talked about the back of the house, but does the height in the front of the house affect your use and your use of your own property?
The concern that we had, and as Mr. Whelan said, was that between the two houses, they constructed a over 5-foot wall, retaining wall between our two properties because of the difference of the gradation where there was. And nowhere else, again, on the street is that a need between two houses to have that high of a retaining wall to keep the properties stable. And that was done based on their civil engineer giving guidance as to what would help not be future concerns that we had regarding soil erosion and property coming towards us, because it is a hill. So the concern still stays that the way that their house starts from the back to the front is a significant difference and is not within the way that all of the other homes, and from any one of our decks, because we do all participate in Red's fireworks on each other's decks, which is one of the fun things that we do in the neighborhood. You can look to the east and see all the way down the street through everyone's deck, and it's a clear view. You look to the west, no matter whose home you're on their deck, and it is blocked when you reach this home because it is a large blue wall that everyone can see. So it does impact others other than ourselves being directly next to them, from the front and the back.
Rob, I would add that I too agree with the McAndrews that it looks out of place in our neighborhood. It's much higher than the other houses. And it also affects the amount of light that we get from that side later in the day because it is so much higher than ours on the front side and the back side.
Okay, thank you. I'm going to share screen. I'm going to, for the benefit of the lawyers and adjudicators in the room, I'm going to try to fly through some exhibits here to authenticate, to make a record. If you'll indulge me, I'm going to do this real quick. And Kit, you can cross-examine on any of these, but at least these will all look familiar to the forum because they have their materials that were previously introduced in a prior proceeding. Mr. Sturkey, I'm going to share my screen if that's okay.
Sure.
Thank you, sir. Tricia, can you see the email that's on the screen? I'm going to call it Ballier Exhibit 1.
Yes, I can.
Okay. You mentioned that there were marketing materials that you received that specifically mentioned the view and that provided views, drone views of the particular views from different areas on your lot. Do you remember that?
I do, yes.
Okay. Is this one of the emails that you received containing those materials?
It is.
Okay. Okay, Tricia, I'm going to show you what I'm going to call Ballier Exhibit 2. Is this the map of the drone views that were contained in the marketing materials?
They are.
Okay.
That is.
Thank you. During your testimony, you mentioned that you were provided at the time of that you submitted your plans, you were provided with a set of rules and regulations, and you ensured conformity of your home. Do you remember testifying to that?
I do, and that is true.
Okay, I'm showing you what I'll call Ballier Exhibit 3. Is this a copy of the Declaration of Covenants and Restrictions of your subdivision?
It is.
Does this contain a provision which requires the properties to be in conformance with zoning?
Yes, it does.
Okay. Let's see. Mr. Sturkey, if you'll indulge me, Mr. Ballier is already sworn, and I need him to authenticate a couple of exhibits. If I can question him contemporaneously here.
Sure.
Thank you. Okay, Mr. Ballier, you at some point did you contact someone from the city to advise of the issue?
I did through email.
Okay. Excuse me, got the wrong one. Okay. Do you remember who you contacted?
It was Emily A. House. And she did respond.
Okay. I'm going to show you what I've marked as what I'll call Ballier Exhibit 4. Is this a copy of your correspondence between yourself and Ms. A. House? And there are, at various points, there are other persons from the zoning department. Does this look familiar?
Yes.
Okay.
Rob, if I could interject for a second, just to mount an objection. We haven't seen any of these materials prior to this hearing, and can't really view them that well in the manner they're being presented. It was our understanding the materials, anything in reliance in this hearing should have been submitted 3 days prior to the hearing. So we just want to put that objection on the record, and if Mr. Sturkey could rule on that, we'd be appreciative.
Rob, do you have any response to that?
Other than these materials they are in the record from the prior correspondence. The submission that the applicant made makes specific reference to the prior hearing. So if they did not familiarize themselves with these materials, then that seems plausible to me. Just that representation that they haven't seen them. But nonetheless, if I would ask for, to the extent that there's a rule of this forum that would require their submission in advance, I would just ask that we be granted leave to submit them now. All they are doing, by the way, is corroborating testimony that's already been given, so that they can be received to that extent.
Mr. Sturkey, they become part of the record. We have not had a time to review them and prepare in response to them. It would be inherently unfair to allow those here, regardless of some offhand reference to a prior appeal, which is not this appeal.
I think I'll overrule the objection. I will allow them into the record to the extent to Mr. Linneman's point to authenticate testimony that's being provided here today.
Okay.
Linneman.
Thank you, sir. Mr. Ballier, then just to follow up, and by the way, I'm happy to allow these. I can email these directly if somebody wants to review them. But Mr. Ballier, is it correct that you contacted the city as early as June 2022 with your concerns?
It is correct.
Okay, then I'm sharing Exhibit 4. I see that the date on this is June 28th, 2022. Mr. Ballier, did you ever contact the Whelan Homes directly?
Patricia, my wife, talked to the foreman, Terry.
Okay. And did you ever, was any written communication ever initiated with Whelan Homes?
From you, when we, only from you, through you.
Understood. Okay. I'm gonna show you what I have. I'm sharing my screen. I'm showing you what I've marked, what I'll refer to as Ballier Exhibit 7. Is this the letter that you directed me to send to Jeff Whelan of Whelan Builders?
It is.
Okay. Okay. Mr. Ballier, are you parties to the zoning appeal that is still pending in the original case, the case that we were here on last year related to the same property?
Yes, we are.
Yeah. Okay. Mr. Sturkey, that's all I have from Mr. and Mrs. Ballier, unless either of them has anything they wanted to add.
No, thank you.
No, thank you.
That's all I have then. Thank you.
Before I give Mr. Hassan an opportunity to ask some questions here, just a couple for the Balliers. So it is your contention that even under this revised plan, that the nonconformity in the front still causes adverse impacts to your property. Is that right?
It does, Mr. Sturkey, and the revised plan has been very unclear, has been discussed as to what is being shown on a drawing versus when we met with Mr. Wheeland and what he explained to us versus what he's explaining today. So I think Mr. Linneman's point as to what point is he actually using to be in compliance for the whole envelope is really germane to all of it. And that has been very unclear. So I don't feel like we understand exactly what he's planning to do.
Got it. Okay. So as we sit here today, you're still not clear what in particular the back of that would look like. Is that right?
Exactly. That is where we have the most questions and still do not have clarity.
I agree with that. The drawings and what we were told when we looked at the deck and what Rob just went through don't match up in my mind. They don't make sense. They don't go together. It seems what they're actually doing is different than what the drawing says.
Got it. Okay. Briefly, I mean, while we're on this point, just to Mr. Houston, Mr. Wheelan, Mr. Linneman, the Deliers, do you think there would be any it would be productive or helpful at all for a discussion to happen about what the current plan is so that everyone is clear on that before I render a decision on this case? What I'm suggesting is the possibility that there's some discussion and clarity during a continuance of some sort of this hearing before we wrap it up and I render a decision. Do you think that would be fruitful at all?
From our side, we are willing to have a further discussion. So that's not a concern for us.
Mr. Stark, I think we can provide that clarification here. And this has gone on for a very long time and had a very adverse financial impact on the applicant. So just to be clear, and I'll let Mr. Wheelan correct me if I'm wrong, the structure as it stands today will remain. The only change would be that the railing has not been installed. The railing will be installed per the as-built drawings. The parapet wall, the city has not objected to that in its decision attached to our brief as Exhibit D. It's not objected to anything on the rear of the house. We're willing to accommodate the neighbors by removing that parapet wall. But again, that's an accommodation. The as-built drawings, they are what they are. They were done by engineers. They should reflect the reality of how the structure is currently stands. But again, the city's decision is solely as to the front of the structure, which we've, have testimony that can't change. So we're willing to make these accommodations. They've been discussed prior to this hearing, and unfortunately, there were some terms that Wheelan couldn't accept. But the parapet wall, we're willing to do that regardless. It is an accommodation just to try to help smooth things over with the neighbors. So I'm not sure that in a continuance would be fruitful. But if there's some sort of request that needs to be made now, we'll certainly entertain it right here on the spot as today at this hearing.
Rob, did you want to respond to that at all? And then we'll get back into the normal course here.
Sure. Yeah. I mean, I think Mrs. Valier stated the position. We're happy to talk, but if there's no opportunity to talk, that's fine. But I will take issue with the contention that that Exhibit F, they are not as-built drawings. The applicant has testified that this is not what it looks like. The words "as-built" are handwritten in blue in we don't know who wrote them. Nowhere on here does it indicate by Mark Durkis Architect that these are as-built drawings. They are not as-built. They are a proposal, and the applicant has testified that these conditions do not exist. So a question that at some point this body is going to have to continue is, can it make a decision based on the fact that there are no as-built drawings?
Make it look like the drawing.
I guess the question is if the applicant will conform the structure to the drawing that is Exhibit F, would that make the neighbors happy? Because that's what we're saying we're going to do. There's a few things that are different on the structure. It's that railing. Jeff, is there anything different from these as-built drawings? And again, they have been handwritten on there as a visual depiction of the structure when it will be completed. What we're asking for is this body to approve Exhibit F to be the structure as constructed for the variance. Is that fair, Jeff? Is there anything you need to add there?
Yes, I would agree. We just didn't make the adjustments to it until we got out of this hearing to figure out what we were going to need to do. And when we met on Monday, the Belliers and I tried to explain to them, hey, here's what I want to do with putting that bottom plate on there. I don't think that I explained it well enough. I didn't change my view or change what I'm doing or anything like that. I just don't think that we're on the same page as far as what I explained. But I think we just, and that's my fault, putting as-built. I put as-built on there thinking of the front of the house. I'm in favor of saying, hey, if we build this thing the way the drawing depicts from the city, like what we showed to the city, what we've submitted for this variance, that puts us in compliance with the back of the house. If we build it like that, are you guys okay with it?
So I think for now, I just want to get clarity on the record. Exhibit F is meant to demonstrate or show plans for what this will look like if this application is approved, right? It is not currently built like this, but these are the plans that you would like to get approved.
Correct.
Okay, got it. I think we were just about to start a portion of cross-examination, unless there was anything else further that any party would like to say on this sort of sidebar that we've had here. No. Okay. Mr. Houston, the floor is yours.
Okay. And it's Bellier. Is that correct? Am I saying your last name correctly?
Yes, that is correct. Thank you.
Okay. Okay, Ms. Bellier, do you recall the first time that you viewed your property prior to your home being constructed?
I would say it would have been in January of 2020.
Approximately.
Approximately
Okay.
January of 2020, because we signed off with our builder in February of 2020 and COVID hit in March of 2020. So that would be the time frame.
Okay, and the hillside that exists there today, that was there in February of 2020, right?
It was, and the street was in, and other properties were beginning too. We were part
Okay.
of the first Homerama homes that went into this development.
Great. Okay, I just wanted to make sure that the hill wasn't constructed later in time. These marketing materials, were they prepared by Wieland, to your knowledge?
No, they were the developers' marketing materials that were shared with all builders and all interested parties in purchasing a lot on this street.
Okay, and I think you testified that you relied on those marketing materials for what your view would be.
It was one of the components, as well as meeting with the builder and understanding from the builder what their site plans and what we could expect.
And who was your builder?
Red Knot.
I'm sorry.
Red Knot.
Red Knot. Okay.
Yep.
And on there's been a lot of talk about the last request for a variance. At any time, did you object to the height of the front of the structure during that proceeding?
We objected to the entire structure.
Okay. So if Wieland is to construct the structure in accordance with the Exhibit F, what's been referred to as the quote unquote as-built drawings, would you still have an objection to that structure?
Again, as I stated earlier, it is unclear to me as to what exactly Wieland is going to be doing, because the drawings aren't as built. That isn't what the structure is today. What has been pointed out by our attorney is that to meet the variance that is being requested for the envelope of building, you would need to go down to that point, which is not what Mr. Wieland said he was going to do. Today, now he's saying he could remove some of the flooring that would actually meet what he's asking for, but that's not what he's suggested previous to today. So in my opinion, it is still very unclear to me as to what actually is he going to do to meet this variance request, which starts at that point in the back of the house and then goes all the way to the front of the house to have the building envelope, which again, is what all of our neighbors and us included were required to fit within. So that's what we're trying to understand. And
Okay.
there have been many versions of that discussed even in this conversation here today.
Okay. If Wieland were to remove the parapet wall and the small portion of the back of the structure that your attorney pointed out during his presentation, would you then be willing to agree with the grant of the variance?
I think we're open to it, but I think we need to discuss that.
What exactly?
My husband and I need to discuss that, and I'm not in a place here where I'm going to agree to something with you.
Okay. Is there anything that you would be able to tell me that would changes to the structure that would allow you to agree with the grant of the variance?
I think that would be what Mr. Sturkey suggested. We have an actual discussion about that and have that opportunity to have a conversation, which my understanding from your comments, you don't want to do. So.
Well, isn't it true that you've had multiple conversations with Wieland, some as recently as yesterday about changes to the structure?
Again, what we've had conversations with Mr. Wieland on is what exactly are you going to do, which what he verbally shared with us and what he sent back in a text that I asked him, because my husband and I both came back from his conversation with different points of understanding what he was telling us based on what he was showing and pointing to us on the parapet wall and where the rubber roofing goes up into the stands of the parapet was not what the drawing showed and not what he has said today. So there is unclarity. It is unclear to me as to exactly what would be done to be able then to make a decision to say, yes, I'm okay with that or not.
He really wasn't open to it.
And he has not been open to having any discussions, and previous attorneys representing him have not been collaborative. So that's why Mr. Sturkey's suggestion of a discussion we're open to, but you're not. So I don't know what to tell you.
Okay. Well, I think that's a mischaracterization of what was stated, but let me ask you this, yes or no, did you or did you not have discussions with Wieland as recently as yesterday about changes that he was willing to make to the structure?
Yes.
Okay. So there have been conversations recently, correct?
We have, but we've been told what he's doing. And when we've made any recommendations at all, for instance, the flooring or removing the parapet wall all the way down, because there's really no need for it if you don't put a railing on, he was very blunt that this is the way he's going to do it. And if it complies with the city, then it's the way he's going to do it.
Okay. No further questions.
Okay. Let's see. Rob, I think I gave Mr. Houston an opportunity to redirect with his client. So if you'd like to take advantage of that, you can do that now.
I don't have anything further.
Okay. One last time, just to be clear, if we were to bring this back in a week to allow for conversation, that is something that the applicant is not interested in doing.
And we're willing to do it. We're skeptical because there's been a lot of conversations had. We think it's clear what we're proposing. We think the back of the structure is in compliance. I believe the city agrees, and we're willing to go above and beyond and remove that parapet wall and even a portion of the back structure, which appears to be the primary complaint. But we're not going to say we will not talk. And if we could reset it in a week, I think that would be great. We think it should be granted, as is, but happy to hear the suggestions.
Yeah, I mean, I think just based on the entirety of the circumstances here, that having a document that everyone can look at agree on. Maybe have any sort of stipulations in writing would go a long way to help rebuild any trust that's been lost over the course of the last couple of years. So, I mean, if that is something that both parties are willing to do, I think it may be helpful. Again, that is, you know, I think it is the balls in each of your courts in regard to that. If you'd like to, that is something I would entertain. We could come back here on Thursday the 16th in the afternoon. If you all believe that would be enough time to have that conversation.
What time would be the proposed hearing on the 16th?
I think anytime 1 o'clock or later.
Yeah, if we could set it for 1 o'clock, that would work with my calendar. It gets pretty clogged up after that. And just to be clear, we're going to come back just to discuss the specific changes that Wheelan's willing to make and then closing arguments.
That's correct. To provide some clarity around exactly what the proposal is, so that the Belliers have a clear understanding of what the proposal is on this and any stipulations that Mr. Wheelan is able to provide. We'll come back in progress, so we won't go through any of the portions of this hearing that we've already covered. I'll allow an update on the discussions, and then we'll go back into your rebuttal, Mr. Houston, if necessary, and make any closing arguments and wrap it up. So I'm hoping that if when we do come back, that it'll be an abridged version and everyone will have a better idea of what exactly the proposal is.
Yeah, that's we can do that, and what we'll try to do is develop some sort of visual depiction of the changes that we're suggesting be made, and Rob, we can send that over to you, and then presumably that would be added to the record as necessary for the issuance of the decision.
Rob, do you need a minute to discuss this with your clients at all, or do you have any objection to a continuance on this matter?
If you'd indulge me, yeah, can we just mute and can I pick up my cell phone and contact him? There on a sort of housekeeping matter, my afternoon next Thursday is pretty crowded. I have commitments at 1
How long will it take you to create
4. I could do it at
Sorry, 1 and what?
1 o'clock and 4 o'clock, so maybe 2 o'clock. And would there be you're saying the record would be closed today, except for any submission? Well, I guess the record wouldn't be closed because we're specifically asking for, okay. So is there a time limit on this proceeding? Because I have a board meeting at 4 p.m. that day.
Yeah, so I think that in order to make sure that we can get this scheduled, I would be happy to put in some time restraints. Like I said, I think I could reserve 5 to 10 minutes for an update on any of the discussions that have happened between now and then. I'll allow 10 to 15 minutes for a rebuttal from Mr. Houston and his client, and then we'll go into closing arguments where I can give 5 to 10 minutes on each of those. So can certainly keep it under an hour. I think it's even possible that we could keep it under 30 minutes with some time restrictions.
Okay. So then I would be if you then can we have 5 minutes and I'll pick up the phone and we'll get right back to you.
Sure. Yeah. And did you say so 2 o'clock would be the only time that would work for you? Is that right?
2 o'clock would be great if we can do that.
Mr. Houston?
Is that what date is that again?
That would be the 16th.
16th.
Fortunately, my husband will be traveling at that time, so we could make 3 o'clock work on our side, but I don't know on that same day if that can fit your schedules.
I have something on my calendar at that time. I should be able to move it though.
3 o'clock, yeah, that's fine.
Allison, does that work, or should we try for a different day?
Yeah, we'll make it work. I think it's important to keep this moving.
Okay.
Agree.
All right. Mr. Linneman, I'll give you a minute here.
Okay, I'm gonna mute and go off.
Sounds good. Thank you. We'll just take a brief recess until they return.
David, this is Wes. Do you want me
Yes.
to provide any comments now or next Thursday? Or there's a couple things I want to clarify or whatever. I don't know what your thoughts are, but
I think we probably should. Let's wait until everyone's back and we'll discuss. Okay, Mr. Linneman,
Yeah,
you
we're
have a
back.
chance?
As you may have discerned from our scheduling conversation, that's great. We're a yes on next
Okay.
week if you want to continue in progress.
Okay. I think the last thing that maybe we'll do today before we continue this, and again, this might just help provide some more clarity going into the discussions that you'll have in the next week, is and cut down on the hearing time next Thursday, is to allow the zoning plans examiner to provide just a little bit of testimony before we adjourn today. Wes?
hi, good afternoon. So I just wanted to outline or clarify that the drawing that on page 7 of the zoning staff report, that's what was submitted for the application, which I think is very similar to Exhibit F.
I'm sharing my screen so everyone can see that.
Yeah, so like I know people talk about removing the parapet wall, so the height limit would be at a 566.5 as noted in with the red circled text there. So this drawing shows the parapet wall does not exist or would not be built along the rear facade line and then extending along each side 6 feet, as referenced in the text right above there. I assume that's what you guys are going to be talking about or confirming. And then the paver situation on the rubber roof, I'm not really sure I understand exactly where that is, but the pavers would not be allowed to extend above the height limit at the very rear of the facade. So that would need to be accounted for. And then the plate that was mentioned by Mr. Wheeland, that again would have to conform to the height limit at the very rear facade point. And then, of course, as you move towards the front, the height limit increases slightly. So, however, having said all that, the red line I drew and each little line on that drawing are probably an inch or two thick. So it's really, we're getting into the really, there's a margin of error that's reasonable to expect on this kind of thing, I think. So I just want to say that. And then one other thing. So there was some discussion by some of the neighbors and such about the scale and how the house fit in. I was looking at the building permit and the site plan data for the Bellier's house and the Wheelan house, and also the Cage's topo during the course of the hearing. The topography does go up at that end of the street. So in fact, the Bellier's house, their rear deck is 3 feet below their height limit. So they could have done their massing a little higher. Just the overall context of those comments, just letting you know that's my thought on that as I reviewed some of the factual information. So the last three houses are all, you know, higher than the other houses towards the east, just in a general sense because of the way the topography is. So thanks.
Thanks, Wes. Okay. Unless there's anything else from the attorneys at this time, I think that we will continue this in progress. Anything?
Very briefly, just to be clear, any changes that we're proposing are going to decrease the height of the structure in the back. Is that correct, Jeff?
Yes.
That's correct. Yes. So just to be clear, anything that we're proposing is going to take the height down, not up.
Thank you. All right. Thanks to everyone for their time and their testimony here today. I know this has been a very long process and saga. I appreciate everyone's willingness to have one more conversation here about this. As we've stated, we will be continuing this matter in progress. We will reconvene on Thursday, May 16th at 3 p.m., where we will be continued in progress. As I said, I will hear sort of a brief statement from each party about the discussions that are had in the next week, and then we will move into a rebuttal portion where Mr. Houston will have an opportunity to respond to anything that he's heard from either Mr. Munzel or the Belliers or members of the public, and then we'll move into closing arguments. I will set time limits on those to try to keep this hearing as efficient as possible. That next day, is everyone okay with a 10-minute time limit on closing arguments for each side?
Yes.
Yes.
Okay, great. All right. And then, I think we'll take as long as we need to update me on those discussions, but for the rebuttal portion, I think I'll also try to limit that to 10 minutes, Mr. Houston, unless you have any issues with it.
That shouldn't be a problem either.
Okay, great. All right. Well, we are continuing in progress. Thank you all again. Hope you have a great day, and see you next